Good afternoon. My name is Beata Leah. I'm an immigration attorney at Minsky, McCormick, and Halligan. And today I wanted to talk to you about what should a terminated H-1B employee do to remain in the United States lawfully. So as a result of the coronavirus, there are, obviously we all know this, massive layoffs in almost every industry. And those layoffs are not only impacting US workers, they're also impacting H-1B workers. So what should they do if they don't want to leave the United States, to remain in the United States lawfully? And what should they do if it's simply not safe for them to depart the United States at this time? Now, obviously, this is a difficult question to answer generally because it's going to depend on the circumstances of the individual, their personal circumstances, whether they're married, whether they have kids, whether they have the finances. But today we're going to discuss three possibilities. First, we're going to talk about the possibility of an H-1B transfer. Second, we're going to talk about the possibility of changing status to F1 student status. And then third, we're going to talk about the possibility of changing status to a tourist status simply to buy time. So again, first we're going to talk about the possibility of changing status, transferring the H-1B to a new employer. So most H-1B workers are familiar with this, but just as a way of background, as a result of regulations that came out 2 years ago, there is now a grace period for H-1B workers. H-1B workers have up to 60 days after termination to figure out what they're doing, whether it is to transfer their H-1B or to so again, the grace period for H-1B workers is typically 60 days, during which time they have the option of transferring to a new employer. And that 60 days is automatic, with the exception that it can only go up until the validity of the prior H-1B approval that that individual has. And so if the individual's prior H-1B expires in less than 60 days, then the individual is not able to utilize the full 60-day grace period to transfer to a new H-1B employer. But again, if the individual was terminated and they have more than 60 days left on their previous H-1B, then they're able to utilize the full 60-day period to transfer to a new H-1B employer. Now, obviously, it's very difficult to find an H-1B employer right now because, again, of these massive layoffs in virtually every city, every industry in the United States. But there are, my understanding, from having worked with many employers, is that there are still some employers that are hiring. Many of them are working in the industries that are responding to the coronavirus, the medical industry, medical manufacturing, universities, hospitals. Technology companies are doing well right now in certain sectors. And so there are companies that are still hiring, and it is, in fact, possible to transfer your H-1B to a new employer if you're able to find one of those jobs in those industries that are still hiring. I also want to recommend that you consider looking not just in your city, but also outside of your city. You know, as a result of the coronavirus, we're all working remotely, and that is the same for H-1B workers. And so your ability to find a new employer is not limited to your city if you're able to work remotely from home. You can look in other cities. You can look in major cities far outside of your city. If you're in New York, you can look for work in San Francisco and work remotely in New York. But also you can look in rural communities, states that perhaps don't have the same impact, don't have the same coronavirus numbers, and maybe they're not as impacted economically as we are in the big cities. And perhaps they have positions available for you to fulfill a specific need, again, where you're able to work remotely. They would list your home location on that H-1B, and you would able to work from home in your own city for an employer outside of your city. Now, later on, it could certainly be negotiated that you would relocate, but again, that is not necessary. You can use an H-1B and you can work from home if your home location is listed on your H-1B. So again, just to summarize, you have 60 days generally after a termination to find a new employer and to transfer your H-1B. I should also say that there is this possibility of maybe doing it beyond 60 days. There are rules in place to forgive a late filing. This is called non pro tunc. It's Latin for, I don't know, I don't speak Latin, but it's Latin for something along the lines of please forgive this late filing. And the USCIS is in fact encouraging people to file such applications. They notified the public about this last week because of the circumstances, and they understand that people are unable to depart the United States, whether it is because there are just no flights, or maybe there's a restriction on entering their own home country right now. And so there is a possibility of even filing this late, but there's no guarantee that they'll accept it. They'll look at the circumstances of why it was filed late and how late it was to determine whether they should allow your late filing. Again, but generally it's 60 days. Now, another option is to file a change of status during that 60-day grace period or shortly thereafter. The change of status, most usually for H-1B workers, terminated H-1B workers, is to F1 student status. So most H-1B workers came to the United States initially on an F1. They're familiar with F1 status, and they're comfortable with, in certain circumstances, again, if they can afford to do so, going back to school. You know, now is a good time to consider pursuing that master's degree. If you came to the United States initially for a bachelor's degree, you got a job based on your bachelor's degree, but then you were terminated and you'd always sort of considered pursuing a master's degree, but maybe it was never the right time. And now as a result of the termination, many people are contemplating going back to school and pursuing a master's degree. So the process of applying for a change of status to an F1 first starts with finding the school that you want to go to. Again, similarly to H-1Bs where you can work remotely, there are many schools where you can study remotely. So you can certainly explore the schools in your area, but you can also explore schools outside of your area where you'd be able to study remotely. I mean, I think all universities right now are basically operating remotely. And so, again, looking for a program that meets your needs, that makes sense for you, both financially and in terms of what your career goals are, and then applying into that program. The school would have to issue an I-20 to allow you to proceed with an application for a change of status to F1. Now, in an F1 application, there are sort of a few key things that you have to demonstrate. You have to demonstrate, first of all, that your intentions are temporary. The F1 is not intended to simply buy you time. You know, you have to explain, why do you need to go to school? Why now? Why here? Why this program? How is this going to advance your career goals long term? And also, it's important to demonstrate that, again, that your intentions in the United States are temporary. An F1 visa has a strong non-immigrant intent requirement. So unlike the H-1B, which permits having dual intent, which permits having the intent to remain in the United States indefinitely, the F-1 requires showing that you are going to ultimately depart the United States. So again, you have to convince the officer that your intentions long-term, you know, in the United States are temporary, and that the purpose of you pursuing this particular degree program will advance your career goals or your personal goals in some way, and that ultimately, after concluding this program, you will depart the United States. Similarly, you have to demonstrate that you can afford to attend this particular program in the United States, sometimes without having work authorization. Some F1 students have work authorization. Other F1 students do not have work authorization. That is a topic that is beyond this presentation, but the point is that you have to demonstrate that you'll be able to afford that program for however long it is, whether it's a 1-year program or a 2-year program or a multi-year program, that you'll be able to afford it for the duration of the program on your own or with the support of a family member or some other co-sponsor. So again, the key requirements for filing for a change of status to an F1 is establishing that your intentions are temporary, explaining why here, why now, and that you can afford the program, and then ultimately that you will leave. Now, one thing to note is that when you file for a change of status to an F1, you also have to, in many cases, file for what's called a B2 bridge. What's interesting is that the USCIS created this pretty unusual requirement a couple of years ago that it's not enough for you to remain in the United States pending a change of status, that you also have to simultaneously have temporary status while waiting on a decision for your change of status. This is really unusual. It doesn't apply to other types of applications. And so what you're doing in essence is you're filing 2 applications. You're filing for a change of status from H-1B to F1, which is your ultimate goal. It's to become a student. But you're also simultaneously, while you're waiting on that change of status to an F1, which is the long-term goal, having to file these extensions of, or this change of status to a B, tourist status, while waiting on the ultimate F1 approval. And those can only be requested in 6-month increments. And so if the change of status to an F1 takes a long time, more than 6 months, we have many cases where you have to file multiple bridge applications for B2 status while waiting on the F1. So again, you'd be filing multiple applications to ultimately obtain your F1 status. Now, finally, the last thing I wanted to talk about is the option of changing your status to a B, just simply a B. Your long-term goal is to accept your fate and depart the United States, for example, but it's just not safe to do so right now. And so, again, the USCIS is encouraging people to file change of status applications to B tourist status, simply to buy you time. Again, you have 60 days after your termination generally to do something, whether it's to find a new H-1B employer, to file for a change of status, or to depart the United States. And again, if it's just not safe for you to depart the United States right now because you're practicing social distancing or your country is on lockdown, then one option is to just buy time. And so you would file that change of status to a B tourist status within the 60-day grace period, and then explain in that application that, again, you've been terminated, you plan on departing, but it is not safe for you to depart right now. You just need to have a little bit more time while this pandemic slows down, I suppose, and then leave. And again, those applications can only be filed in 6-month increments. And so if you do need to buy yourself more time, it's possible that you would have to file more than one, requesting an additional 6 months if necessary. What's interesting is that the government often takes longer than 6 months to adjudicate these applications. And so there are situations where you're filing that subsequent 6-month request even before getting a decision on the previous 6-month request. So you have to track how, when did that 6 months that you've requested, when does that end? Because even though you are still waiting in the United States on a decision, the government has not yet reviewed your first request, and now you have to file another one. And similar to the change of status to an F1, what goes into one of those applications, again, is an explanation of why you're changing your status, why here, why now. Well, that's simple. You can't leave. It's not safe for you to leave right now. And then, can you afford to stay in the United States without work authorization for the next 6 months? You know, do you have money in a bank account or a family member who's going to support you? And then your temporary intention that you plan on leaving. One of the things that is often requested by USCIS in these applications is proof of your ties back home. This applies to F1 applications. This applies to B2 applications for tourist status. Convince the USCIS that, again, ultimately you will leave, that they're going to grant you this 6-month extension, but that you will leave afterwards. So how can you convince them? You prove to them that you have a family back home, you have a home back home, you have maybe a job offer back home. So whatever ties you can show to establish that you will depart timely once this all clears up or slows down. Okay, so again, in summary, today we talked about the 60-day grace period for filing any kind of application or departing the United States after a termination, looking for H-1B employment and transferring your H-1B, particularly maybe even outside of your jurisdiction, outside of your city, just if there are opportunities elsewhere, because you can work from home on an H-1B. Filing for a change of status to F1 status if that makes sense for you personally and financially. And then as a last resort, filing for a change of status to a B2 simply to buy you some time. So if you have any questions or you need help with any of these, please feel free to call 312-427-6163. My name is Beata. I'd be happy to help. Stay safe, everyone.